So who's in control here? Honestly, who's in control of this interview? Certainly ain't these two cops. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl-handled pistol cufflinks so graciously gifted to me by none other than the content genius that you guys know as my son, Michael Rivers. So today we're reacting, to an interrogation. Interrogations are a tricky thing for the cops. You got some guys who like to act like good cop, and some guys that like to act like bad cop. I almost universally recommend don't snitch. Well, not snitch, but don't, not snitch on yourself, but don't submit to an interrogation, because the first time anybody should hear your story is when you tell it on the stand. But sometimes it makes sense to talk to the cops. For example, if you have an alibi that's airtight. But, you don't know what the cops know. So when they'll ask you questions that they know the answer to already to just try to test you. So this is actually DaBaby, and then the title of this video is When a Criminal is Smarter Than the Police. If you remember our last episode, my basement was flooded because of a haphazard thing my grandparents did in my basement. And I had to call and get a cleaning company in, and we did it all by e-sign. That happens all the time. And so now they're being interrogated by cops, and, the first thing they did was hire a lawyer. And they couldn't go to his office because they're in wheelchairs. So they e-signed a document. They both are very prolific with their laptops. And so what the lawyers did is they did an e-sign document to them, an e-sign retainer. It's a very simple and easy way to do business. It's a simple way to remotely do business. Download the app, you get 3 free signatures a month, and you are able to do business quickly and remotely. So once they did that, they lawyered up, and because they had a lawyer now, they're waiting trial. Poor grandparents. They just developed a bad habit, and it started with OnlyFans, and now we're into this. Anyway, well, let's get to this. This is When a Criminal is Smarter. I haven't seen this. This is a totally cold reaction. So I haven't seen this. It's called When a Criminal is Smarter Than the Police.
This boy. I know if y'all had proof of me robbing somebody, we wouldn't even be talking. Y'all would.
I know if you had proof of me robbing somebody, we wouldn't even be talking. There is some truth to that.
Cuff me, I would be charged with it. That's what I know, bro.
In January of 2020, DaBaby, aka Jonathan Kirk, was supposed to be playing a show at a nightclub in Miami. But when the owner paid him only $20 out of the $30,000 he owed him, things got out of hand fast. The victim alleged that Kirk punched him in the face multiple times before he was attacked by more of Kirk's crew. He was beaten up and knocked to the ground before being robbed for his phone, his credit card, and $80 cash.
See, these are all very not petty crimes, but small crimes in terms of, why would somebody who's like DaBaby be involved in stuff like that?
The only footage of the event was this piece of obscured CCTV footage. Kirk fled the scene in a black SUV before returning to the hotel a few hours later, only to be met by both of the victims and a team of police waiting to arrest him. He was escorted to the police station and told he was only there as part of an investigation.
Shit, we just gotta do our investigation and that's it.
But as it was
to arrest somebody, just so you know, you have to have probable cause for an arrest. We don't have preventative detention like they do in Romania.
turn out, the investigation wouldn't be that simple. And unfortunately for the cops, Kirk spent his hour in the interrogation room displaying exactly what to do in this situation and making the cops.
What happens sometimes, they'll leave you in a room, and maybe they even leave with your cell phone, and they'll just try to get stuff out of you by just sitting and watching your behavior. So they'll sit there. You can sit there for a couple hours, and they do that on purpose.
Lives as difficult as he possibly could.
What's your full name? Come on.
We just want to go through. This is just a formality. Just name, date of birth, and all that stuff.
Immediately, it's obvious that this isn't going to be an easy one for the detectives. Kirk starts off by refusing to answer any of the officer's questions, even just regarding his own.
Now keep in mind, there's you have to have Miranda. Well, what is Miranda? The Miranda warning is when you have an in custody interrogation. So they have to read him his rights, and it doesn't sound like they've done that so far. And otherwise he's free to go, right? And so if he's refusing, and if he would have invoked his right to a lawyer right then and there, they have to cease questioning.
Name. He's already been read his Miranda rights, informing him that he has the right to remain silent, so it seems as though he's choosing to do just that. Interestingly, however, he is choosing to waive his right to a lawyer, and let's be honest here, it's not because he can't afford it. The best course of action if you're ever put in this scenario is to stay silent and ask for a lawyer. But this time, Kirk is confident that he'll be able to wriggle out of this himself.
So many people inflate their sense of their ability to talk themselves out of a situation like this, and so you don't know what they know, and so you don't know so you could unwittingly either corroborate or make it look like you're lying about something, and that's why we typically don't do these interrogations or recommend not giving a statement to the cops.
As long as he chooses his words carefully.
An incident occurred at the hotel, 1500 Southwest First Avenue, that you were there for, correct?
What incident?
An incident. You had an altercation with somebody?
No.
You didn't. Did you have a business dealing with somebody?
No.
You didn't.
No.
So somebody didn't bring you $20,000 in front of the hotel in your SUV?
No. Somebody bring $20,000 that wasn't theirs and lied to them and told them that it was for an event of theirs on the 31st. And lied to them. That person, once he realized they were doing bad business, said nah and left for his $20,000.
Okay, so you didn't count.
And got my contact information to do business the right way. That's what happened.
Around what time was this, sir?
I don't know. Whatever time they told us. Whatever time the camera showed me not robbing no damn body that time.
Kirk is claiming that.
So whatever time the damn camera saw me robbing nobody, that's the damn time.
Claiming that he had nothing to do with anything that happened outside. His story is somewhat unclear, but he's essentially saying that his manager was talking with an event promoter about playing at a nightclub called Cafe Iguana Pines. But it turns out the money that they were offering was stolen, and the promoter was acting strange during the deal. So instead of taking it and going through with it anyway, he told them to get their act together and left without an argument. This, of course, does not explain the altercation outside that was clearly caught on camera, but with the footage unclear and no witnesses nearby to identify the assailants, as long as Kirk sticks to his story, theoretically, things should be.
And typically, people are intimidated by cops. The average person is. And so they wind up giving too much or contradictory information, so they either look like they're lying or they look like they're guilty. And that's what these guys do all the time.
Perfectly fine.
Common sense. You know what I made to even be down here? A promoter booked me at that hotel. I didn't pay to be at the hotel. I was paid for. You'd have let me in my room, you would have saw close to $250,000 cash, legally, hard-earned money. I don't got to take nothing from nobody, bro.
So let me ask you this.
See, that is a fact. But sometimes, as we know from other cases, like the Shiesty case, where people can have a ton of money and they still do stupid shit.
I will go outside here right now and throw $10,000 in the air. Like, I do not care about no money. I don't.
Was there an argument?
No, it was an argument. I didn't argue with a soul. My voice was never raised. There was never aggressive language from me. None of that.
Was there a fight?
None of that. No, I ain't seen no fight. And nothing was taken. We shouldn't be in no robbery, bro. So when y'all get done doing what y'all doing, y'all need to do y'all job. Y'all need to follow y'all process. And y'all need to arrest whoever gave y'all these false allegations, bro. This is bullshit.
While it may just look like Kirk is flexing his rapper money here, this is actually a very good point for him to bring up in this situation. If he's doing random $30,000 deals on a weekday and paying for hundreds of thousands of people per month, what does he need $80 and an iPhone for? The further he can place himself...
if I'm him, I'm worried about where that $250,000 is, because I've seen it time and time again where cops actually walk off with money.
The further he can place himself from this event, both literally and figuratively, the better. From Kirk's point of view, he was nowhere near that crime. He had no reason to commit that crime, and he has sound and reasonable explanation for his whereabouts.
And it just doesn't seem, if you've got that kind of dough, it seems like just petty bullshit. It doesn't seem like that would fit your MO.
At the time. However, from the detective's side, a crime was committed, and Kirk's vehicle was right there as it happened. So they need to try and extract the information needed to piece his day together to come up with a story that Kirk cannot argue with. That forces him into a confession.
When I encountered you in the hotel, you came back to the concierge, the counter.
Yeah.
Where were you coming from at that point?
Prime, whatever the hell. I went to eat. I went to get some food.
Where is that?
I don't remember.
You don't know?
No.
How'd you get there?
In the car.
What kind of car? Was it a car you drove? Somebody else drove?
Uber.
A Uber?
Yeah.
What kind of car was it? Small car, SUV, truck, what?
I don't know. Let's talk about what matters.
That's why we're here.
Let's talk about what y'all need to get me about this stuff. When I'm driving in the car, when I went to go eat, what time I went, that don't have nothing to do with the fact I ain't robbed a damn soul. Me, nobody around me, ain't nobody robbing nobody.
Let's take the word robbery out of the picture.
So while we here, we taking the word robbery out of the picture. Y'all are robbery detectives. This is robbery unit. That's the second word he said. That's the second word he said when he came in here. Robbery. Come on, bro.
Okay, listen.
He told me he asked a question to me about a robbery when I walked in my hotel.
So who's in control here? Honestly, who's in control of this interview? Certainly ain't these two cops. And he's very confident in his alibi. And it's kind of fun to watch him actually take control of the situation.
Robbery? I had every answer to the question you needed right there. Whoa, that ain't it. That's false. Okay, throw that out the window. We talking about robbery, bro. It's nothing for me to talk about. I didn't rob.
So do you think that we just woke up this morning and decided to just...
I think y'all got a phone call from somebody that's already a liar. I know they're a liar. Got a phone call from somebody that's a liar, and y'all bought it. Y'all believed it. Y'all got me in here, and y'all put me in handcuffs. Brought me outside the hotel in handcuffs, cameras and shit all on me. Come on, bro. This shit is bad for what I got going on. And I ain't even do shit to that man.
Even without a lawyer present, Kirk knows exactly what to do. He currently has the upper hand in this interrogation and needs to keep it that way. The cops are searching for anything that puts Kirk at the scene of the crime, but by redirecting the conversation away from that, back to what he thinks is actually important, there's no realistic way that they'll be able to get what they need. But even though he's winning, it's still worth noting how strange it is that he's not asking for a lawyer. Kirk obviously knows exactly what to do in an interrogation and has clearly spent time learning what to do. If that's true...
I don't know about that. I don't know that he's well versed in interrogation techniques. He's just confident in the facts. And when you're making a story up, you have different body language and a different demeanor than if you're not. And your story doesn't change either. So he just seems confident in the facts. And keep in mind, he's been through a murder charge before and beat it. And that was in a Walmart where he was attacked. And it was a self-defense case.
He should also know that there's next to no scenarios where lawyering up will harm his case. But whether it's an ego thing or just a lapse in his thinking, Kirk is definitely still winning this interrogation. But he's about to start absolutely dominating.
We talking about criminals. When I do business, it's legally binding. It's legally binding. Everything I do, you have to sign a contract. You got to sign a contract.
Okay,
it's a contract right now.
The whole incident happened and nothing went wrong. Nothing happened. There was no...
Not to my knowledge.
There was no fight. There was no scuffle. There was no...
I ain't fighting nobody. But y'all know it's too much. Y'all know too many lies. You get what I'm saying? That's why y'all got to move backwards like that, bro. Like
you're saying that they're lies, but you don't know what we have or don't have.
Okay.
That's
I know if y'all had proof of me robbing somebody, we wouldn't even be talking. Y'all would have cuffed me. I would be charged with it.
They did cuff him, and they haven't charged him yet, but they did cuff him and they did arrest him.
That's what I know, bro. That's what I know.
Now, while this isn't necessarily true in every case, it is absolutely true here. If you're in an interrogation room and the cops are trying to find out details of the case and accusing you of a crime instead of charging you immediately, it very likely means that they're missing the details needed to charge you. In the vast majority of cases, an interrogation is only done to extract a confession when they don't have enough evidence to easily convict you otherwise. There are a few other niche scenarios such as
That's true in some measure, but it seems to me that regardless if they have the goods or they don't have the goods, they generally want, especially on more serious felonies, they want to nail the defendant down so that they give a confession.
is trying to figure out why you committed a crime, but it's often very easy to distinguish why exactly you're there based on what you know about the event and what questions they're asking. If the cops know that you're guilty and have irrefutable evidence, cooperation has a lot of merit. But if they can't prove you did what they say you did, stay silent and ask for a lawyer, especially if you're innocent.
I ain't hear your side of the story.
My side of the story is I ain't done that. I don't have a side of the story because I ain't done nothing to nobody. Bro.
So that's what I was asking. So
and before something could be done to
nothing
me,
happened, right?
and before something could be done to me, I realized I was dealing with bad business, and I
Why do you say it was bad
from
business?
What?
Why do you say it was bad
I
business?
already told y'all that. You want to rewind this? You want to rewind it, bro? I already told y'all, bro.
Do you rewind it? You want to rewind it, bro?
My story not gonna come out different no matter how many times I say it, bro. It's not, bro. It's right here. So you press stop and rewind and play, you're going to hear.
Press stop, rewind, and play. Yeah, I do like how confident he is in his story.
That's why I said it was bad business, bro. Come on, bro. There's nothing blowing my phone up. I was say, oh, no. He needed my help for his event. He already was in deep water because he's already doing, and I see why, he's already doing bad business. You see what I'm saying? He has an event that wasn't going to go as planned. He needed me to make up for that. He needed me to cover his ass, so he brought in another person, lied to him, swindled him. He thinking he coming to book me for a whole different event, and they tricking him, got him paying me to come do.
So who's in charge? The baby's in charge. Period. I mean, it's just not even close. And the reason you can tell that is he's dominating the conversation. He's not allowing them to get a word in edgewise or ask the questions they want to ask. And he's just not given an inch on his set of facts. And that lends more credibility to, or leads, gives him more credibility that he's telling the truth.
Walk through the night. Come on, bro. These niggas full of shit. And matter of fact, check them cameras. Y'all got crime.
Check the cameras. Check the cameras, check this, check that. We have cameras everywhere in the city. It can track you from one end of the city to the next. And if he's telling you to go look at the cameras, that means he knows he's not going to be on there. It means he's telling the truth.
Scene investigation unit out there, check the cameras. See him meet up with somebody else in the lobby. Ask him, hey, who's that? Ask him. Follow up on what I'm telling y'all.
That's what we're trying to do.
At the end of the day, I would expect people to act on common sense anyway.
The cops have realized that they're definitely not getting anything out of him for now. He's told his side of the story and made it clear that it won't be changing, no matter what they say. So, as is the protocol here, the detectives decide to leave the room and spend some time outside trying to come up with their next move.
And here's the thing. This is also a tactic to get the person to come alive. Because even if he doesn't testify, the state could still use his testimony or his recording against him. I had a client, she gave a statement, said she didn't do anything. Then they left her in there for hours, and it was a video just like this. And you could just see, she's doing all kinds of weird stuff, and they played that for the jury. And it didn't bode well for her at all.
This is also often done as it gives the suspect time alone in the room to sit and build up anxiety. In many cases, it can actually be the difference between breaking through a suspect or not. But in this case, Kirk literally just shut his eyes and went to sleep, spending some time in jail while they figured out what to do and gathered all the evidence they could. So they just had to figure out what to do with his stuff while he was locked up. But obviously, Kirk refused to let them touch his stuff and just let the hotel deal with it. Kirk was facing a possible sentence of up to 15 years in prison plus a $10,000 fine, plus any charges they could slap him with for the battery. That's only if they could gather enough evidence, though.
And they don't have an eyewitness, it doesn't appear. Certainly not one that's willing to come forward.
Evidence they absolutely were not getting from Kirk, or the blocked security footage that was the only evidence the crime even took place. So just after 48 hours in jail, DeBaby was released and sent on his way.
So you think about that. He sat for 2 days in jail, didn't get charged with anything, and in my opinion, they didn't even have probable cause to arrest him. Think about that. He sat for 2 days in jail without the hint of any kind of criminal charges. And so what do you do with that? I mean, so what do you do with that? There's not much you can do with that. I mean, does he have redress? Not really, because you can't, they have qualified immunity. But, I remember I've taken a client in on a homicide once, but we worked with him for 4 hours prior to bringing him into the cops. There was a warrant out for his arrest, a pick up and hold. It's a thing they do here in Minnesota. And it's where they have, they don't have full probable cause, but they want to question somebody. So they issue a pick up and hold. It's not really a warrant. In my opinion, it's unconstitutional. We worked with my client for 4 hours and then brought him in, did the interrogation, and it turned out he had absolutely nothing to do with it. But he was a nervous wreck. And he was a young black kid in North Minneapolis. And had he been left to the streets, they would have shot him. I guarantee it was a high-profile murder case. We were able to show that he was not there. He didn't witness anything. He knew some of the same people, but we were able to clear his name. And so that was an instance where it made sense to go in and talk to the cops. But we don't really do that very often. We frown on it 99% of the time. So this has been our reaction to DeBaby. And DeBaby in this particular situation was smarter than the cops. Why? Probably because he had truth on his side. And he knew that he didn't do anything. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer with our content genius, Michael Rivers. So make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please is at my god.
164 Echo Hotel and 164 Echo.
Get back.
Get back. He doesn't like her perfume or her body odor or something. Maybe her breath. I don't know. This guy does not want to be there at all.
Okay. And when you say you're an adult, what number and years are you?
I plead the fifth.
You can't plead the fifth to your age.
My window.
Yes. I don't remember what I done told the police.
Okay. Let me ask you this. Are you just saying yes now to speed up your questioning?
Most definitely.
Okay. Are you asking Jans to just answer this just so you can speed it up and get the fuck out of here? And it's kind of funny, actually. If I'm the defense lawyer watching the prosecutor struggle with this guy, I'm laughing my ass off.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers from Criminal Lawyer Reacts. Welcome to another fun-filled episode. We are accompanied by our content genius who's behind the camera. I'm your board-certified criminal defense lawyer, Bruce Rivers, here to give you commentary on the latest news of the day, on funny things that happen, on true crime, on whatever strikes our content genius's fancy. His name is Michael Rivers, and he is my son, and this is a project, father-son project of love and devotion. So that's what we do. And I am your board certified. I'm here for you specifically. Today we're going to react to Little Woody and some of the crap that's gone on in this case. I cannot believe this judge for one thing. I just can't believe how he's treating the parties. I can't believe the state, honestly, how they're treating the defense. I can believe the defense reacting and maybe I'm biased because I come from that side, I could never be a prosecutor. I could never be a prosecutor, not in a million years. But you know what I could do? I tell you what I could do. I could go to eforms.com if I needed a form, a legal form. My grandma does it all the time. Your grandma should do it. Everybody should do it. eforms.com is a very effective way to avoid the high-priced lawyer like me. They're a sponsor of our channel. We appreciate them so much. If you're selling a car, private sale, get a bill of sale, because the person who buys the car, if they don't transfer the title, if they use it for an illegal purpose, you got to have a documentation that you actually sold the car. Just because you sign over the title doesn't mean that they're going to take care of it. Or if you have a medical power of attorney need, if you have a power of attorney, rental agreement, any kind of legal form that you need, go to eforms.com. You're able to protect yourself and keep yourself out of court and keep high-priced lawyers out of your pocket. eforms.com. Okay, so let's just kind of recap a little bit about what's been going on with Lil Woody. Lil Woody is probably the most difficult witness I've ever seen in my life. We're going to show you some clips of him. And when a prosecutor deals with a difficult witness, when you deal with a gang case, generally speaking, you're not supposed to testify if you're a gang member. Why is that? Because you're snitching, right? And if your snitches get stitches and they wind up in ditches, and that's what happens. I mean, it does happen. I've seen it happen. I've seen people get beat up. I've seen people get killed. It's very dangerous to testify as a snitch.
How many bodies have been dropped on that corner?
I told you, let me tell you this. Y'all probably seen right there posting it. I went over there and I talked to the people who got shot. Mm-hmm. You know what I mean? I spoke with them.
Okay.
Now, he just asked him how many bodies have been dropped in that corner. This does not look like somebody who's a typical cooperator.
I got to speak with them. I seen police right there, uncover, whatever y'all call them. I seen them. I didn't say nothing. I talked with them and I told everybody, I said, hey man, listen, I ain't trying to tell y'all what to do, bro. But y'all just gotta start hanging. Now, if these people have outside in the back, these niggas don't care, they just shoot. This shit here right nice game. Y'all niggas arguing about $20. I gave these niggas $20.
Yeah.
And y'all niggas still come here and do that. They start hanging over there.
It's the same game though that you had when you were, and I get it.
Really, but I get caught up because I be trying to play fucking peacemaker to shit instead of just letting niggas do what they do, because this one stupid fool got all these different niggas around. Mm-hmm.
So one of the issues in this case has been the prosecutor will ask him a question, and he won't answer the question, and he won't even come close to answer it, and maybe he'll take the fifth. And one of the things they've asked him about is prior statements. Do you remember giving a prior statement to the officer on such and such a date? He said, I don't know. I don't remember what I said to the officer. And what they're trying to get him to say is either I remember, and this is what I said, or I don't remember, and I never said that. Because if you say, I remember, and this is what I said, then they can play the recording, and that turns out to be a prior consistent statement. It's an exception to the hearsay rule. If he says, I never said that, then he's disavowing the statement, well, then they can play it as a prior inconsistent statement. See what I'm saying? But if he doesn't remember, it falls in kind of the middle land.
Got all these different niggas around. Mm-hmm. That shit don't mix. So, I told him, hey, I was done going to Mechanicsville. That's why I was on Bankhead, because I said, shit, ain't nobody coming on Bankhead. You know what I mean? And I'm not going to be called. The police ain't going to be saying, oh, Woody did this is because of Woody over here. And there are kids out there too, but it's not going to be nothing because of the way the apartment is made. Ain't nobody coming up in those apartments. Mm-hmm. But my whole thing is, man, I promise, man, I mean, y'all tired of me saying the same shit, but man,
it's not.
I'm risking my life giving y'all this information because I know for 100% sure only 4 people know about this information.
So did you hear what he said in that last clip? He says, I'm risking my life here in this situation. That's why these things are so dangerous. I mean, Young Thug is not on trial for just dealing a little smack on the corner. I mean, it's not what he's on trial for. He's on trial for an organized criminal enterprise that involves murder. And so that's why these stakes are so high. So we have these prior statements of Lil Woody, and the prosecutor wants to get everything that he said in. But this is the kind of person that you're dealing with Lil Woody. And it's kind of funny, actually. If I'm the defense lawyer watching the prosecutor struggle with this guy, I'm laughing my ass off.
Do you recall what Thug said in 2015 to Kel?
Yes.
Yes, you remember what Thug said?
I don't recall what was said. I don't remember what was said.
Okay.
I don't.
Okay. Do you recall what was said? Yes. Then the next question should be, what did he say? But I don't know why the prosecutor just asked that question over again. But then he says, I don't remember what he said.
I don't remember me talking to the investigators about it.
All right. Do you remember telling Detective Gaither that when Kel got on the phone, that Thug said the beef ain't over with until you pay for my window?
Objection leading. You know, and I don't know if the prosecutor has established that he's a hostile witness. She may have. So here's what happens with a hostile witness. So you get your witness on the stand, and it turns out he's not going to give you shit. In other words, he's not going to say what you know he's supposed to say. In other words, he's given a statement in the past. All you got to do is testify consistent with your prior statement. But if they're giving you shit and they appear to be hostile to you, in other words, they're more on the defense side, well, then you can ask the court for leave to consider him a hostile witness. What does that mean? When you call a witness, you have to ask them questions on direct in a non-leading fashion. In other words, you have to say, what happened next? And did you go to the party? Who was at the party? What did you do at the party? You know, and give those open-ended questions, as opposed to that you went to that party and Young Thug was at that party, right? And when you saw Young Thug at that party, you saw him with a firearm, correct? And when you saw him with a firearm, you also saw him point the firearm. It's, you know, I mean, that's not part of this case. I'm just using that as an illustrative example. But that's the difference between a direct, non-leading question that calls for an open-ended answer as opposed to a leading question that calls for a yes or no answer. And on direct examination, you're not supposed to be able to do that. However, if they're declared a hostile witness, then you're able to lead the witness.
Shot my window.
Yes.
Yes, you remember telling Detective Gaither that?
I don't remember what I done told the police.
Okay. Let me ask you this. Are you just saying yes now to speed up your questioning?
Most definitely.
Are you asking Jansen just answer this just so you can speed it up and get the fuck out of here? Yeah, that's exactly what I'm doing. He is if you the defense is going to look at this and say, look, you cannot rely on this person's word for anything. And I think they'd be right in saying that. One of the things that, if you don't want to testify, let's say I get to court and I plead the fifth. Then the prosecutor says, grant you immunity. Well, the Fifth Amendment only applies if you have criminal liability in front of you. So, like, if they ask you what your age is, and I plead the fifth, there's no criminal liability with my fucking age, right? And so you can't plead the fifth on your age.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
How old are you? Grown. I'm grown. He's just fucking with them at every turn. Doesn't want to answer a single question. And I don't blame him.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
You can't plead the fifth to your fucking age. Telling somebody your age is not going to expose you to criminal liability.
Gentlemen, can I get you to step outside to your headquarters of jury deliberation?
So when you plead the fifth like that, just first of all, you're not, generally speaking, you don't do that in front of the court or in front of the jury. The court doesn't really allow that because it's prejudicial. But if you remember what happened with Lil Woody early, it's about a week or two ago, Lil Woody was taken into chambers, and he was taken into chambers ex parte with the judge and the prosecutor. What that means is they talked with him with his lawyer, and they didn't allow the defense in there. It was improper. It was absolutely improper for them to do that, especially when you're dealing with a sworn witness. So let me give you an example how this works. So a witness gets on the stand. There's not supposed to be anything that gets in between the witness and their testimony while they're on the stand, after they're sworn. Nothing. No outside influences. It's just your testimony. If something like the fifth comes up like that and they go into chambers, defense should definitely be there, because there's no privilege. I think the judge is absolutely wrong when he says there's some kind of privilege to have this ex parte communication with a sworn witness that's on the fucking stand. One of the admonitions that a judge gives, a witness, if there's a break in their testimony. So let's say before lunch, the witness testifies and they get to the lunch break and they break, and then the witness is going to come back on the stand after lunch. Well, the prosecutor can't talk to the witness in between times. The defense can't talk to the witness. The witness can't talk to anybody else about the case or about their testimony. It's improper. It's 100% improper. And for the judge to take this witness into chambers with the prosecutor and not allow the defense to witness what's going on, were they threatened? And my guess is that he was threatened with criminal prosecution. And you saw him in a jumpsuit earlier. Why was he in a jumpsuit earlier? He was in a jumpsuit earlier because he was taken into custody for contempt of court. That's another thing. If somebody doesn't want to testify, it's not like they can make him testify. But you know what they can do? They can hold him in jail until that case is over or until they testify, one of the two.
Do you see Shannon in the courtroom today?
Well, I got a vision problem.
Okay.
I can't see that far.
All right, so if you want to
I got a vision problem. I can't see that far.
stand up and look around the courtroom and look around the entire courtroom, tell me if you see Shannon in the courtroom today.
This guy does not want to be there at all.
Do you need to sit down?
Nah, I can right here. They ain't had nothing to drink.
Okay, do you want some water?
You gonna give me a drink?
I'll get some.
What does he want? Does he want a drink? What kind of drink does he want?
Drink.
I'll get some water.
I don't drink water.
Well, I don't have nothing.
I don't drink water. I've never seen anybody so obstreperous on the witness stand.
Nothing else for you, but I will put some water up there for you.
Who am I looking for?
Shannon.
I think I see him.
Okay.
Notice he's in a jumpsuit. Why is he in a jumpsuit?
When you say you think, you can have a seat. When you say you think you see him, what do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think the lady got red hair.
Okay, so you pointing to a lady and not Shannon?
The lady with the red hair. Why the fuck would you... I mean, I don't know if this witness is so critical to their case, and maybe he is, but he certainly isn't helping them one iota.
No, the one behind her.
Okay, so you're saying you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
Well, it looked like her.
Okay. Does anybody else over there look like Shannon?
Yeah.
Okay.
Somebody else looks like... I was trying to murder a case one time, and they thought they had my client dead to rights. The guy comes in, he says, did you have a party on, June whatever? He said, yeah, I had a party. Was Chew at the party? Yeah, Chew was at the party. Do you see Chew in the courtroom here today? No, Chew ain't here. It's like, oh, thank you. Mr. Rivers, do you have any questions? Why would I have any questions? Chew's not here.
Who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay. What's his hairstyle?
Bald head.
So you're saying Shannon's the one with the bald head? Or he's sitting behind him?
Shannon's the one with the bald head.
He's sitting behind the dude with the bald head. I think that's him.
Okay.
It's two people with dreads. I can't see. I just see dreads.
Okay. Let me just say.
That's one of the problems when you have a multi-defendant case like this, especially when you get somebody who doesn't want to testify. it's very difficult to pinpoint who he's talking about. And then we have a picture of him here sleeping. And then if you look at some of his pictures, there's one video.
164 Echo Hotel and 164 Echo.
Get back.
Get back. He doesn't like her perfume or her body odor or something. Maybe her breath. I don't know. That's just plain embarrassing.
Excuse me.
Sir. I'm sorry, can you take a break?
No, I said excuse me.
Oh, okay.
I don't know what's going on. As I learned, you said that there'll be a hearing this morning with his lawyer. It's been dark since.
He's had, okay. Mr. Copeland's had the opportunity to speak with his lawyer, Miss Bumpus, and it is my understanding he's going to testify. That's the latest I can give you, okay? So we're going to bring Mr. Copeland out, and we'll see what happens.
So one of the things that has happened here is because of this ex parte hearing that the judge had in chambers with the witness's lawyer and with the prosecution and without the defense, the defense has asked for a mistrial. Let's take a look at the concerns that Brian Steele had, in 2023. This case has been going on for so long. Jury selection took forever in this case. This judge does not have a command of this trial at all.
Specifically is on the recording threatening KC that he will get, that she spoke with the U.S. Attorney's Office, and he is facing, if he does not cooperate against Mr. Williams, he's facing 25 years at a minimum on gun charges in federal court, and there's no parole. I do not have one document, not one note or memoranda provided in discovery concerning ATF agent Cunningham.
So that's a problem. So you think being threatened with prosecution for 25 years isn't a strong motivator? Let's see what else Brian Steele had to say about this topic.
Upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order.
One of the reasons they've filed a motion to recuse is because the judge is now a witness to the conversation and the coercion, if there was any, of the ex parte communication that was had in chambers.
And I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up.
So let's take a look at Brian Steele's reaction to the judge's denial of their motion.
I have read Baptiste versus State. I've read all the cases that I believe are applicable, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion. where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list.
So when you add the judge to the witness list, this is some bold shit. I mean, I've never done that in a million years. But I have asked the judge to recuse himself, and I've asked for a mistrial, but it's not that often that happens. And how many times have we heard the word mistrial in this case? A lot. And so if the judge becomes a witness, he can't be a witness and a judge at the same time. Just like you can't be a lawyer and a witness in the same case, unless you're representing yourself. So it's called a witness advocacy rule.
I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it,
it's important for the defense to have that, because especially before he testifies on cross, because if he's threatened with criminal prosecution, or if he's offered anything in exchange for his testimony, that's got to get disclosed to the defense. And apparently the judge has kind of revisited that issue.
I understand it, there is zero privilege, so I don't understand
I'm
how.
not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Ms. Weaver is going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a
eating on the bench and that's just such bad form.
The defense group will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that.
Well, he changed his mind on that a little bit, because I think earlier on said he never made a commitment to give that over to the defense.
And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
All right, that is interesting. So what he's saying there is, if you have a witness that's represented, it's unethical for a lawyer to contact that witness. You need to go through the lawyers. But I mean, how do they know she didn't go through the lawyer? Essentially what has to happen here is, you file an affidavit and a motion. It's got to be timely. And then the judge has to go through and make sure that, number one, it's timely. Number two, make sure the affidavit is sufficient. If that's the case, then he's got to assign this to another judge to hear the recusal motion. The judge didn't do that. He's not going to do that. He just dismisses their motion out of hand. So there's just there's a lot here that the judge is doing that is mucking up this case. All he had to do was invite the defense in when they had this ex parte communication with the witness, who was sworn and already on the stand. But he didn't do that. And it's given the defense, and then he puts the judge or the lawyer in jail, or tries to put the lawyer in jail, for not revealing who told him about this ex parte communication. So it's just a shit show. And the judge is not in control of this case at all. But there's a lot to unpack there. There's a lot there for an appellate court. But here's the thing. So you got multiple lawyers asking for mistrial. You got all kinds of allegations of recusal, of inappropriate, intimidating a witness. And he says, well, you can take it up with the Court of Appeals. But he won't give them a certificate to do it now because he doesn't want to stop the trial, because that will stop the trial for the short term. And so he won't allow them to appeal it. It's really just, so what we have here is a situation where, the judge is really acting out of character in cases that I've seen anyway. And there's a lot there for the defense to argue that he should get a new trial should Young Thug get convicted. So this is just our little reaction to Woody and Brian Steele's reaction to all the shenanigans going on. And so we'll see you next time here on Criminal Lawyer Reacts. Clodagh, this is for you. We'll see you next time here on Criminal Lawyer Reacts. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts. So I think you're going to see a much more efficient trial being run by this judge. I think what you're going to see here is a little tighter ship. She wants to get this trial done. 6 months. 6 months. There's just no rhyme or reason that this case should have taken this long. And we're getting some of our information from Thugger Daily. And so we shout out to Thugger Daily because he's following this like tooth and nail and doing an excellent job. And she's on the stand, right? So we're taking a break and we're in chambers. She's going to say this, and this. And I'm like, where the hell did that come from? And I said, that's fine. I've got other witnesses that are going to piss all over her anyway. And and I just said that. I just blurted it out. And the judge looked at me and said, excuse me? And I'm like, shit, what did I just say? This was a long time ago. I was much younger, and I was much less mature than I am now. There's a new sheriff in town, and her name is Judge Whittaker. Court will begin at 8:45, no matter what, regardless of whether the defendants have any of their lawyers present. No more eating in court unless the day goes on longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants. Sorry, Thug. Asking to minimize disruptions in the court. Defendants cannot be using headphones during the trial. And no gaps between witnesses. State needs to have their next witness available immediately. So what you're going to get from this judge is a more tightly run ship. Slow down, Bruce. Slow down. A lot of things going on in this case that are just don't happen in normal cases. You don't have 3 judges. They're on their 3rd judge now. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your personal board-certified criminal defense lawyer, here with our content genius, Michael Rivers, who's behind the plan, behind the stand, behind everything, including every idea I ever came up with, because he is the content genius. Today we're reacting to the news that there's a new judge, a new sheriff in town on the YSL trial, and she's not taking shit off of nobody. And so okay, let's just back up a little bit. So Judge Glanville, who has been handling this case for way too fucking long, hang on. Let me back up. I'm getting ahead of myself because I'm so excited. This episode is brought to you by our sponsor, eForms.com. eForms.com is a very effective way to protect yourself legally if you need a form. You need a form for, selling your grandma's wheelchair because, she just doesn't need it. You get a bill of sale. Or you get a power of attorney because your grandma's a millionaire and you want to take control of her assets. She's living in your basement and she's eating Cheetos and has her girlfriends over and you just need to control her affairs. So you can or you need a power of attorney for her medical. Or if you need a rental agreement because grandma's got money and you think, oh, she's not a freeloader, she's going to pay some rent. Well, anything you need to do to protect yourself, legally speaking, go to eForms.com. It's an effective way to avoid a high-priced lawyer, whether it's me or somebody else. So, and it protects you once you get to court, because if it's in writing, you can't argue with the document, and the other party has to sign it. So go to eforms.com, good way to protect yourself. Okay, slow down, Bruce. Slow down. A lot of things going on in this case that are just don't happen in normal cases. You don't have 3 judges. They're on their 3rd judge now. So Judge Glanville had a motion to recuse himself from the case back in June. That was denied. The Court of Appeals have come back and granted that motion. I don't know if it's Court of Appeals or another judge, but that motion has now been granted. The order on that recusal motion is not saying that Judge Glanville couldn't be fair or whatever. It was basically saying there's might be an appearance of impropriety at this point. And that's why it wasn't basically on the substance, it was basically on the appearance of some impropriety. And Steele and Glanville, if you remember those video clips of the two of them kind of going at it, I mean, it was just harsh. And he tried to put him in jail. And he was vindictive when he said, "Where did you get that information from?" Watch. And
what I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
And so then Judge Ingram was assigned to the case, and then she recused herself, probably because she doesn't want to be a part of this shit show. But I think there was some initial motions that she ruled on early on regarding Steele. I think there was a motion to get Steele off the case because he had represented so many people, and the government said he's a critical witness, which they haven't called him, and he's not a critical witness in this case. So now we have Judge Whitaker. And Judge Reese Whitaker is a judge who Brian Steele and other defense lawyers threw a fundraiser for her re-election campaign. We do that all the time. I mean, we're in politics, you know. I did that for a judge. I hosted a fundraiser, and she walked out with thousands of dollars, and thank you very much. But it doesn't mean that she rules my favor anytime I go in front of her. She's just a good friend. But it seems insidious. All right. So let's just take a look at the new rules. The new rules. There's a new sheriff in town, and her name is Judge Whitaker. Court will begin at 8:45, no matter what time, if all the defendants, regardless of whether the defendants have any of their lawyers present. No more eating in court unless the day goes on longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants. Sorry, thug. Asking to minimize disruptions in the court. Defendants cannot be using headphones during the trial, and no gaps between witnesses. State needs to have their next witness available immediately. So what you're going to get from this judge is a more tightly run ship, okay? And there's just no way that this should be taking as long as it is. If this was federal court, this would have been over a long time ago. They took, 8 months to do jury selection? That's insane. That's absolutely insane. There's just it should have maybe taken a week to 3 weeks at best. And if it was in federal court, it would have been done in less than a week. For sure. For fucking sure. So let's just take a look at, so Steele files a motion. He filed a motion to exclude all of Copeland's testimony because the rule is if a judge has been recused from a case, any proceedings in front of that judge after the motion has been filed are stricken from the record. So now we got to start all over with Copeland. Does that mean the state can call him again? So he wants their notes taken away from them. He wants his testimony stricken from the record. And I don't know if he's going to get that or not. So let's take a look and see what the tenor is going to be in court with Judge Whitaker.
So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot.
Tempers have flared, but not just from the defense, from the Judge Glanville, and the prosecutor. And it's not uncommon. In every case that I handle, I try to be professional. But once in a while, somebody gets under your skin or whatever, and tempers fly. I remember one time, and I can't even believe I said this, we were in chambers, and all of a sudden the prosecutor comes out with this statement from the witness that never happened. It's like all of a sudden she just thought, and she's on the stand, right? So we're taking a break, and we're in chambers. She's going to say this, and this. And I'm like, where the hell did that come from? And I said, that's fine. I've got other witnesses that are going to piss all over her anyway. And and I just said that. I just blurted it out. And the judge looked at me and said, excuse me? And I'm like, shit, what did I just say? This was a long time ago. I was much younger, and I was much less mature than I am now. But you get in the heat of the battle, and you see how animated that Steele has gotten. You see how animated the judge has gotten. They've all gotten unprofessional.
And that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather. And everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay?
That's excellent. What a great tone to set. As you start out as the new judge in this case. And we're getting some of our information from Thugger Daily, and so we shout out to Thugger Daily because he's following this like tooth and nail and doing an excellent job. But let's hear, from the status conference, the motion with Brian Steele.
So I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it, taken away and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
So what he's basically saying is that he filed a motion to recuse Judge Glanville. He denied that motion. They took testimony after that motion was filed from Copeland, Lil Woody, and then the motion was later granted, and it wasn't granted on substance, I don't think. It was really more granted on an appearance of impropriety rather than actual, bias. But, so the theory from the defense is that anything that happened after Judge Glanville's the motion to recuse Judge Glanville happened, that you got to get rid of all of it. And there's case law that says that. So if you listen to the tone of Judge Whitaker, she's new to the case, says she hasn't been following the case. The jury's on a break now for 2 weeks until August 5th. And let's just get a little more flavor of what her attitude is.
All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Yeah, there's no way. The rulings have been made, and there's no way you go back and you're not going to redo this whole trial. That's not appropriate.
Once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well.
I think what you're going to see here is a little tighter ship. You know, she wants to get this trial done. 6 months. 6 months. There's just no rhyme or reason that this case should have taken this long.
But the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
See, and she's to the point. She's direct.
I think it was originally combat border.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And whether they're going to present a case or not. A realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly, because this case has been going on for a really long time.
She's mindful of the fact that it's ridiculously managed, and it should be over by now.
And there is a rule that lets me exclude cumulative evidence, and I might end up using that. So how about y'all give me a heads up on all of that, okay?
So if the prosecutor brings in a witness and somebody else already testified about those facts, maybe one, to reemphasize a point, but not over and over and over and over again. So they're going to be back on Tuesday at 8:45 sharp, without headphones, without a fancy wardrobe, and you're either there at 8:45 and we start, or you're not at 8:45 and we start. So this judge is basically laying down the law and trying to be as kind, and you can hear her tone. Her tone is very congenial, right? But what she's saying is not congenial. What she's saying is, we're going to run a tighter ship, we're going to get this trial done, and we're going to get it done in a lot short order than we had before. And she's not going to put up with the state, I'm running out of witnesses today. No. That ain't going to happen. Boom, 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 boom. So I think you're going to see a much more efficient trial being run by this judge. And quite honestly, that's what the jury needs. I mean, there's no way this case should have gone on this long. 10 months for jury selection? That's insane. That is absolutely insane. If it really would take that long, then you should break it up. Here's one of the other problems that you have. It's 6 months now, right, of testimony. Jurors forget shit. And the message that's being imparted, what are you going to have, like a 3-day closing argument? Who's going to fucking listen to that shit? Nobody. And your message is going to get lost. You need to be boom, boom, boom. You make your point, get out. And I think this prosecutor is doing the courtroom a disservice. And Judge Glanville has allowed it to go on for so long. And I'm glad he's off this case. He proved himself to be very ineffective. And we're going to see a much more streamlined trial presentation from here on out. You watch. And you're not going to see her, meaning Judge Whitaker, take a whole lot of shit from Brian Steele or from Miss Love. You're not gonna see it. But we got a whole bunch of motions flying this way and flying that way. And guess what? She's going to rule from the bench, and she's going to rule like that. She's going to rule fairly quickly. the judge is going to hear all kinds of motions. You know, you got a motion to exclude Copeland's testimony. You got motions by the prosecutors. I don't know what the hell their motions are, but they're filing motions back and forth. And then you got a motion to recuse Love because she's a critical witness in this case, which, if you recall early on, they did the same thing to Steele. You know, and that's not going to go anywhere. And that's based upon Miss Love texting a witness, and it is what it is. So we'll see what happens. I don't think they're going to get disqualified. I would caution Steele against filing motions that are frivolous because I don't think this judge is going to take too kindly to it. And she's going to be boom. I think that's what you're going to see. You're going to see her being a little more curt than right now. She's kind of in the honeymoon phase and just trying to lay down the ground rules in a very nice and polite fashion. I don't think you're going to see that moving forward. I don't think she's going to be rude, but I think she's going to be decisive, and I think she's going to be curt with people who are wasting the court's time. And that's what's been going on. The court's wasted the court's time up till now. We're going to keep we'll keep on this. Shout out to Thugger Daily because you can get a lot of good information. It's where we get some of our information. I just put a legal spin on stuff that he's presented, and you just watch. This is going to be a much more streamlined trial. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer. You know who you are. And we'll see you next time here on Criminal Lawyer Reacts. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Sign up for Patreon. And on Facebook. Make sure you go to Facebook and just blow that crap up because we're putting all kinds of older content on there that you may not have seen. And new and old stuff. So make sure you go to Facebook. CLR, Bruce Rivers. See you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another episode of CLR, Bruce Rivers Criminal Lawyer Reacts. I am a board-certified criminal defense lawyer. In fact, I'm waiting for a verdict right now. I actually try cases, and first I want to give a shout-out to all our fans, and want to just say we really appreciate you. These things are flying off the shelf. You guys are really supporting us. Our channel's grown incredibly over the last several months, and I just want to say it's not growing without appreciation by me. So I really appreciate our fans. We have the best fans on the planet. Anyway, today we're doing an update on NBA Youngboy, aka Kenneth D. Golden. Now, Mr. Golden, as you know, is in Baton Rouge, Louisiana, and he's charged with a couple of firearms violations. He has a prior record, so it's illegal for him to possess a firearm. And if you are just possessing the firearm, it's a 5-year mandatory minimum sentence, federally speaking, that is. And that's where he's charged in federal court. Well, what's been going on with Mr. Youngboy? Well, a couple things. His lawyer, by the name of Drew Finling, and Drew Finling is a very, very top-tier kick-ass lawyer. He is former president of the National Association for Criminal Defense Lawyers. He's based out of Atlanta, and he is working with another firm with Yigal Bender, Andre Bellinger, Ian Hipwell, James Massena, and Tanner Woods. They're all from the same firm. When you are going into another jurisdiction, you can practice if you're not licensed there if you have somebody there to vouch for you. And they call that pro hoc vice. So what I'm assuming happened here is that Mr. Finling associated with the firm, this Massenoff firm, and they are representing Mr. Golden, NBA Youngboy, and they are admitted, and he's admitted to that jurisdiction called pro hoc vice. And so what's been going on with this case? Well, a couple things. One, they filed a motion to suppress some evidence because the evidence that they have that he possessed these firearms, I believe, came from somebody's phone or came from the video, and they had to get a search warrant in order to get into that device. And so the cops, when they do that, they draft an affidavit for the search warrant. And when they do that, they bring the cops bring it to a judge, and the judge signs it, and then they can search the area that's listed. Well, the thing about it is they can't mislead the judge in order to get the warrant. And so the allegation that they've made in this case is that the 911 caller who called on to give them the basis for the warrant was an anonymous caller to begin with. But the application for the warrant said one thing, and the actual call said something completely different. So we'll see what happens with that. When you file a motion to suppress, basically what you're telling the judge is, Judge, the cops broke the law when they violated my client's constitutional rights. So you have a Fourth Amendment right to the unreasonable search and seizures, okay? You can't, warrantless searches are generally banned, except under certain circumstances. But they got a warrant in this case. But if they got the warrant through trickery or through falsehoods, that's a violation of the law. And when the cops violate the law, the remedy for that is suppression of the evidence. And so let's say you're driving down the road and the cop stops you. You're drunk off your ass. And he didn't have probable cause to stop you. Well, when you file a motion to suppress, anything that happens after that, it's fruit, and the judge rules in your favor that it was illegal, then it's fruit of the poisonous tree, they call it. And then that evidence is suppressed. So in the example I just gave you of a DUI, if the stop is bad, then anything they got, all the observations, the test, anything after that is suppressed as fruit of the poisonous tree. They can't go forward, they have to dismiss. And in this case, I don't know what all the evidence that they have, but let's just say the only evidence they have is this video. All right. Then if the judge sides with NBA Youngboys team and they say, you're right, the cops did mislead the judge in order to get this warrant, I'm suppressing it, then they can't use the video. And if the video is the only thing that they have to suggest that he was in possession of this firearm, then the case goes away and it has to be dismissed. I don't know if that's going to happen in this case or not, but I can tell you this, knowing what I know about cops, especially in Baton Rouge, and knowing who Finling is, and he wouldn't make this assertion if he didn't have something to back it up. You never do that because you lose credibility with the court. So if he's got some teeth there, I think he may have an opportunity to get rid of this case. But even if he does, NBA Youngboy's got another case over in L.A. that he's fighting. So we'll talk about that in a second. Now, but the more pressing thing that's going on with Mr. Youngboy is that they filed a motion to reopen his detention hearing. And they did so with a plan. And the plan was two things. One, he bought a home in Utah. He agreed to hire a security staff to watch him 24/7, ex-Marines and whatever. And then they had some testimony of a couple witnesses, and they had, some other promises. And so here's what we have. We have the chief judge, Shelley Dick, ordered him detained back in April of this year. When she ordered him detained, there's two things that they look at. They look at risk of flight, and they look at danger to the public. And they have to be convinced that there aren't any conditions or set of conditions that could reasonably assure the safety of the public and the return to court. So those are the two things that they're concerned with. Well, when they made their pitch to the judge, they had this woman by the name of I believe it's Kyrie Oliver. Now, Kyrie Oliver was a mentor of Mr. Golden's. She was a tutor out of, I believe, Baton Rouge. And but it's interesting that she was somehow given a salary or a fee of $600,000 in January, between January and February of this year, and for celebrity assistant services. I would like that gig. But she's agreed to go stay with him and keep an eye on him and make sure that he stays. Well, the judge was persuaded in this case, and she's ordered his release. However, we'll get into his actual release in a second. She did not insist that he has his 24-hour security detail with the Marines. But she did say he's got to come up with at least $500,000 cash to go into his lawyer's trust account, or a $1.5 million property bond. So here's the thing. The average guy would not be getting out. And I'll be honest with you, if this happened in Minnesota, he would not be getting out. And I was telling everybody, I don't think he's getting out. Now, is he getting out? Not right away. Why not? Because he's got another hold in L.A. If you remember, when he got picked up last December, he ran from the cops and had a gun with him, and they detained him in L.A. However, it is my guess that a judge in LA is not going to upset what the judge in Baton Rouge is going to do. So the judge in and here's the other thing. So she's ordered that he can go to his home in Utah, but she also ordered a curfew, and the curfew is basically you can't have more than 3 people in the at his home at any given time, and the judge has to approve whoever is going to be present there at his home. Much the same as you would in a jail. You have to put your name on a list to go visit somebody at the jail, and certain people aren't allowed. Like if you have a record, or if you have an offense, or whatever, or if you're a co-defendant. So, and in this case, Mr. Youngboy is going to be, I believe he's going to get released. And I think that makes a lot of people really happy. He's super popular, and he's got some dough, and he's got some resources that the average guy just doesn't have. So he's got an incredible team. He's very, very well taken care of legally. And they've earned their keep on this particular deal. So he's looking at a hard 5 years in Louisiana. He's also looking at another hard 5 in LA. And one of the things that happens is these counts are usually consecutive to each other. So, and that's mandatory. That's not discretionary. So he's looking at a hard 10 years. But looking at the filings that I have, and I've got the indictment right here, I've got the release order right here. So I've actually looked into the filings, and we've also looked into the suppression motion that the defense has filed. And he's got top talent. So if they can't do it, it can't be done. That's my opinion on that. But he definitely has a fight on his hands. Even if let's say they get the camera suppressed. I don't know what other evidence that they have. I don't know necessarily that it would mean that it would be the end of the case necessarily. Looking at the indictment, they have the firearms that he's allegedly possessed. They have the serial numbers. They know everything about him. One was a .45 caliber pistol, a 9mm pistol. So if they have those, they couldn't have gotten those just off the video alone. So what other evidence that they had that he possessed him, I don't know, because it doesn't say in the indictment, and I'm not privy to the discovery. So, but I've had a lot of these kinds of cases, but not with anybody as big as NBA Youngboy, but he's getting some treatment that the average guy wouldn't get, and the reason he's getting it is because he's got some dough, and he's able to afford the resources and and most people going up against the government, it's not a fair fight. This is more of a fair fight because he's got top talent. So that's what we know about NBA Youngboy. It'll be interesting to see how this case goes forward, because here's the thing. Long story short, this case is going to be won or lost at the pretrial stage. Getting that evidence suppressed is huge, and weakening the government's case that way is the probably quickest path to victory for Mr. Golden. So this has been another episode of Criminal Lawyer Reacts with the NBA Youngboy update. Just want to tell you to find us on Instagram, find us on Twitter. You sign up for Patreon. Within 3 months, you get a free hat, and we use that money to get people out of jail and who can't afford it. Don't forget to like this video and subscribe. And if you're a hater, say whatever the fuck you want. because we like the negative comments just as much as we like the positive ones. See you next time.